My name is Dr. Walt Cupson.
My name is Ray Beavis.
My name is Peter Strada.
My name is Holly Sullivan, and I am the president of the Connecticut Citizens Defense League.
I read your written testimony, and I was not sure that I believed that I was reading it correctly, but in your oral testimony this morning, you confirmed that I did read it correctly. Right now, what is the standard that has to be met in order for a court to seize somebody's firearms under a risk warrant?
Under a risk warrant pursuant to the Constitution, the standard is probable cause.
Probable cause.
Probable cause.
You're proposing that be reduced to good faith belief. So the standard would be good faith belief.
Correct, for the standard for a person to be ordered to turn in their own weapons.
So essentially, if somebody goes into court on a standard of good faith belief, gets an order from the court and refuses to turn over their firearms based on a good faith belief standard, sounds to me like they're then going to get a knock on the door for violating that order and have their firearms seized. So in effect, that good faith belief standard turns into a warrant for the seizure of their firearms.
If you don't comply with a court order, I guess you would be correct.
Specific to an order that simply takes somebody's property away, can you think of any other time that order specifically does that based upon anything less than probable cause?
No, in criminal law, I wouldn't be able to, I can't think. Sure.
What you just said was when the guns would be destroyed, you said that they wouldn't be destroyed without a court order. Did I hear that correctly?
Yes.
So on numerous occasions, we've destroyed firearms without a court order, because what happens is people get a protective or restraining order against them that doesn't order their firearms destroyed. They sign a form that says that they have 1 year to transfer those to an FFL or have the order dropped and become eligible and get them back. And if not, they get destroyed without a court order. Isn't that true?
Well, I'm not familiar with the form that you're stating. I would have to research what the legal basis is for the form for your particular police department that indicates that. So,
it says in the state statutes that when you become ineligible because of a protective order restraining order, and you are ordered to turn over your firearms, if you don't become eligible to possess them within a year or transfer them to an FFL in the case of protective or restraining order, and that's a little different with a risk warrant, but with protective or restraining order, then they get destroyed without a court order. That's in the statute.
If that's in the statute, then you'd be correct.
The Supreme Court has laid out in Eldridge versus Matthews, has found that many property deprivations can happen based on an ex parte process, including garnishing of wages, seizure of secured property, private property, the denial of disability benefits. Are you aware of cases like that in the U.S. Supreme Court that have found those sorts of deprivations, those sorts of civil property deprivations, procedurally appropriate under the Due Process Clause of the 5th and 14th Amendments?
I slept through a lot of civil procedures, so I don't know. It was a while ago.
You made a reference that if something passes the legislature, it's deemed to be constitutional. I just like to have a confirmation from you that that's not necessarily the case.
That would be in violation of the Constitution as interpreted by either our courts or the United States Supreme Court.
I happen to know that there are colleagues of mine that their good faith belief is that private gun ownership is something that should not exist. I just wanted you to acknowledge that there's a portion of the population that believes that. And we're putting something into statute that says that that's a good enough reason to take someone else's firearms.
I think there are strong feelings on both sides of this particular issue.
My concern with this is that we live in a very polarized and politically charged society. Would you acknowledge that there may be a sizable portion of our population, and by sizable, I mean 20%, 30%, maybe more, that would agree that any person possessing a firearm might be a danger to themselves or others?
I don't know if I can answer that. I don't know. I haven't seen a poll on that in the USA Today.
Well, Mr. Lawler, I suggest sticking around for the testimony today because I think it's going to become quite clear from the people that come testify that they believe, a lot of them do, the people that will be supporting this legislation. I would say that the majority of them are coming simply because they believe that no one should have the right to own or possess a firearm, not for any particular reason other than the fact that they just disagree with private gun ownership.
This is also non-infringement under the Second Amendment. Any arguments that suggest otherwise should be disregarded.
I noticed that we're only dealing with guns here. If the intent is to protect people from killing themselves, why wouldn't we be taking away, key fobs and those kinds of things to prevent those alternative means of doing harm? Why are we focused on guns here?
But when we talk about guns and we talk about suicide, the means matter, meaning the method in which people use some way to attempt suicide or ultimately complete suicide really matters. And when we look at guns being used in attempted suicide, studies show that people are 80% and higher successful in completing suicide. But when they use any other means to attempt suicide, that rate drops to somewhere around 20%. So we know that the gun and the access to the gun makes a highly volatile situation almost always lethal. And so that is why we are concentrating on the gun.
Okay, I'll work on digesting that. But moving to homicides, which is the other aspect of this, protect others from this individual. As of 2018, the statistics in this country are comparing knives to rifles or long guns. It's about 6 times more knives than rifles. So once again, why just guns if we're looking to protect people? Why not go after knives as well? And, it appears to me that we're just focused on guns. Are we really caring about those potential homicides? So if you could explain once again why guns, if at least comparing rifles or long guns to knives, it's about 6 times more.
Well, once again, first, I'd like to point out this is not a anti-gun, pro-gun thing. That we are asking for a procedure that has worked over the last 20 years. And then if the gun owner wants the gun back after that 180 days, then I believe the standard is only preponderance of the evidence.
This law, this permission extends to a daughter-in-law, brother or sister-in-law, no matter their connection to the individual. It doesn't have to be somebody who lives with them or has even been to the home. You would concur with that.
I don't think that who is allowed to petition the court is as important as the burden of proof that is required to issue such an order. And I do think that someone who is an in-law, but that has intimate knowledge of somebody's mental state or maybe have overheard something. And I think it's also important to note that right now under the current statute, anyone can petition the police, like anyone. And I was actually present for a hearing, I think it was in 2019, in which someone's coworkers had overheard a man say that if he had been given a certain assignment, he was going to make Sandy Hook look like a joke, and that he was going to commit another mass shooting. His coworkers took this very seriously, and they confiscated his weapons and probably saved a lot of lives in the process.
And in that situation, sir, the current system worked. Those individuals contacted the police. The police inquired of the individual. They conducted an investigation. They asked the judge to order an at-risk warrant. The judge did. It was a hearing. The judge sustained the order. and potentially lives were saved. But we're not here on that today. We're here on changing that, expanding that, allowing other individuals on a lower standard, an officer who was doing the investigation. In fact, I believe under the current statute, it can't be a single officer. It has to be 2 police officers or a state's attorney. They have to assert probable cause. They know of the standard in their papers. Whereas an individual is contemplated by this new procedure or additional procedure is not held to that standard that the 2 police officers or the state's attorney are held, correct?
I do think that in that case, the law did work. So I do agree with you on that. Yes, we are looking to expand the law. As far as the burden of proof, I don't think that it is correct that it is a lower standard to be met by citizens that aren't police or state's attorneys. I believe that the way that the law is drafted is that the court still has to make a determination of probable cause before an order is issued. So I don't think that the standard is lowered at all. But nonetheless, the standard could be raised by the legislature, where it is more the procedure than the burden of proof that we're talking about here. And if the legislature feels that the burden of proof should be higher, then the legislature has the right to do that.
So would you, because that shifts the onus to the complainant who
Correct.
Originally made, would you be in favor of that? Because the way this is drafted, you're putting the onus on one petitioning to get back.
I think that the way that the law is drafted is that the burden would be on the gun owner, and that has been upheld around the country in risk warrant type laws as well as others. I believe that is the state's attorney's preference. When we spoke to the state's attorney's office, their opinion is that is the best way to enforce this law is to put that burden on the gun owner, the person who wants to get their guns back. The legislature could, if they wanted to shift that burden, put that burden on the state. But I think the most important thing is that there is a determination by a court, one way or the other, before the guns are automatically just returned to someone who may still be at risk to kill themselves or others.
Now, bringing us back to the good faith, that gatekeeper function, to be able as a third party to apply for one of these things. I want to give you a scenario. So a few months ago, I represented a woman who she had unfortunately been beat up by her boyfriend, and he was arrested. He got a criminal protective order against him, keeping him away from her. And of course, as a result of the criminal protective order, any firearms that were in his possession, he would have had to surrender. Well, the next day he went to family court and he got a family violence restraining order against her. Court found probable cause. And as a result of that, her firearms were taken away. She was defenseless. Under this system, as is proposed, he would have been able to petition for that at-risk warrant at a lower standard than we presently have for our violence restraining orders. Would be the process. Good faith belief would allow him to petition. So how do I wrap my arms around that?
Once again, Representative Fishbein, people lie in court all the time. People are going to lie before you in this hearing. I'm sure you've heard people lie right before you. So it shouldn't be taken lightly that people lie before a judge or a police officer or even before this tribunal. I think that that we need to make sure that people are protected from that kind of mistreatment. But the point of this law is to remove firearms from that situation. And we also have separate laws for domestic violence. But the idea is get the gun out of the hands of someone who's going to kill people immediately Police currently can go to the court without the gun owner being present, and the court hears the evidence without the ability of the gun owner being able to present their own evidence.
Yeah, in fact, there is no evidence presented, sir, when the petition is originally sought. It's a piece of paper.
Well, that is evidence. I mean,
evidence, sir, unless it's cross-examinable. So it's an affidavit. It's a document. It is of some support that a judge should have reliance upon it. But as you, sir, indicated, people lie.
Right now, under the current law, a complaint can be issued by any state's attorney or assistant state's attorney or any two police officers. Is it fair to say that each of those people has been trained in what probable cause means?
I would assume, and I would hope, that the police and the prosecutors are trained on what probable cause is, just as every attorney is trained on what probable cause is, but the term of art.
Well, but it's a legal term, and those particular individuals are charged with the task of determining whether probable cause exists, right?
It is ultimately the court that is, yes. I mean, I think where you're getting at is that police every day have to make those probable cause determinations when they are making arrests.
Well, it's actually those individuals who are charged under the law, because they shall not make a complaint unless they have conducted an independent investigation and determined that such probable cause exists and that there is no reasonable alternative available. That's the current law. So it's their determination of probable cause as to whether or not a complaint gets issued. I'm talking about the complaint that is submitted to the court.
Yes, they must believe that they have probable cause in order to submit the affidavit, but ultimately it will be the court that makes a finding that they have met their burden before any type of order shall be issued. And that is the protection that we have available in our court system.
So at the moment, these professionals, the state's attorney, the assistant state's attorney, or police officers are required to conduct an investigation and with their training determine whether or not probable cause exists and there is no reasonable alternative.
That's correct. That's correct.
Okay. And under this bill, we eliminate all that and we say any household member or family member can submit a complaint without the investigation and without a determination of probable cause. Respectfully, Mr. Stein, you're talking around my question. My question is with regard to submitting a complaint, not with regard to the order, with regard to submitting the complaint. Right now, a complaint may not be submitted unless the state's attorney, assistant state's attorney, or police officer conduct an investigation and determine that probable cause exists and that there's no reasonable alternative. So before a complaint can be submitted to the court, those things need to be established to that standard. And under this bill, in order to submit a complaint, those would no longer be applicable.
Would be applicable to people other than state's attorneys and police officers.
Now we have family member or a household member that can submit a complaint without probable cause and without an investigation and without there being no reasonable alternatives available.
Would be able to submit a complaint, correct?
The Division of Criminal Justice interpreted the language of this statute to mean that because those individuals, the family or household members, are typically not trained in what probable cause means, they interpret it to be a good faith belief. So the court would be determining issuing an order based on whether or not this person has a good faith belief that a person poses an imminent risk of personal injury to himself or herself or others.
I don't think that's correct. And I think I think you're with all due respect, Representative Dubitsky, I think you're misreading the law.
I'm speaking today in support of HB 6355, an act concerning risk protection orders. You've all heard the statistics that red flag laws are on the books in 18 states and in Washington, D.C. In 12 of those states, family members can directly petition the court. Currently, family members approach the law enforcement in at least 40% of these cases seeking firearm seizure orders. Residents and medical professionals need to be able to go directly to the court, and this will translate into lives saved. Many will say, oh, the government's infringing on my rights. This is not really the whole picture. These are mothers, sisters, wives, and brothers, and loved ones who are seeking to stay safe and keep loved ones from self-harm. They're the ones asking for protection. This law has been shown to lower the incidence of firearm suicide and gun violence. It's especially necessary now in this time of isolation and increased mental stressors. Please vote yes on 6355 and save a life. Thank you.
One of the things that you may be missing is that women, mothers, daughters, abused spouses, often try to protect themselves with firearms. And let me ask you, if this bill passes and a man who has been beating and abusing his spouse is being kept from her because she is now armed herself against him, would this bill not make it now easy for him to just go into court and get a court order to remove her firearm and to disarm him and allow him to get at her where she had been previously protecting herself?
I actually know of women who have been in this situation, and no, they did not arm themselves with guns. What they did was they went through the legal process. As you said, we have laws in place. They have safe shelter. Things worked out. What you're saying is a hypothetical that, if you have kids in the house having guns, it's probably not a great idea. I probably know how you feel about that, but I feel pretty strongly about that too.
We've had risk warrant bills up before, and we have had dozens and dozens of women come and testify, abused women, people who have been beaten, women who have been beaten within an inch of their lives and have armed themselves to protect themselves from their abusers. And under this bill, it would make it very simple for their abuser to just go into court without any police investigation and get an order to disarm the abused spouse. Aren't the lives of the abused women that are being disarmed and made vulnerable, aren't they important too?
Are you done? I think it's a little disturbing that you're urging battered women to arm themselves. They have alternatives. You should be steering them towards more helpful situations that can help them get to safety. That's my only comment to you, sir.
I just wanted to say I actually do have this situation now with a client. It's not a hypothetical for us who do practice in this area of family law. Wife has a gun and husband is getting very close to, well, you don't know what he's going to do, right? And unfortunately, a piece of paper, as I tell my clients, a piece of paper is not going to save you. I agree, ma'am, and I thank you for your testimony that the legal process is the way to go. But in the moment, if somebody, a husband comes in the door attacking the wife, that's what she has. The legal process at that point isn't going to help her. So, if that's something we can work on, but I just want to let you know these are real situations, unfortunately, that actually do occur. And but again, I thank you for your testimony.
I just don't think that arming people is necessarily the answer. I know I might be on the minority here, but that's how I feel, and that's my stance.
Not exactly sure that the questions that were posed by Representative Dubinsky was necessarily advocating that women bear arms, but certainly there are women who choose to bear arms. And I think that's what we're trying to take into consideration when we're looking at developing a new proposal that essentially, whether you're a woman or a man, would certainly put into question their ability to rightfully bear arms if there are false accusations made. I believe you had made in your testimony reference to statistics of the number of states who have similar language that's being proposed here now. Is that correct? And could you repeat that?
The red flag law is on the books in 18 states. Again, I'm not an expert. I'm just a citizen speaking my mind.
I'm referring it to you because you're the one who had it in your testimony.
Well, I don't have that. If you give me 20 minutes, I can Google it and find it.
No, that's
Sorry.
fine. I certainly don't want to ask you to do any additional work. Just wanted to make sure that you had the opportunity to back that information, because what I was going to follow up, and I'll ask the question, and you may not know it. Are you familiar with the current laws that we have on the books regarding risk warrants in the state of Connecticut?
Not personally, but vaguely. Again, I'm not a lawyer. I haven't been involved in this. All I know is I know a couple of people that have been affected by gun violence, specifically gun suicide. That's why I'm here.
My name is Brooke Cheney. I'm a mom. I'm a firearms instructor and a competitor. I'm also a mental health advocate. For the past, I come here to you today in opposition of 6355. Like you, I've heard most all of the same objections. Mine is absolutely around mental health. My understanding is that doctors are a possible expansion on the list. As a gun owner who works to help break the stigma around mental health, this is not a step in the correct direction. Education is what I wish we were talking about, not more legislation.
When somebody submits testimony under oath, makes a false statement, that's a crime. Would that be what your position would be as the safeguard to prevent somebody gaining one of these orders, not correctly using that information?
Well, I think there's two safeguards. The most important safeguard is it's the judge who issues the extreme risk protection order, not the the complainant or the person entering the order. So I mean, making the complaint. So that's the first protection, is a judge is using criteria to determine the outcome. And the second one is the risk of committing perjury. And I think for many people, the thought of spending 5 years in jail potentially, in order to harass somebody is probably not a very palatable outcome.
Are you aware of individual states' attorneys' positions in certain districts regarding arresting people for making false statements in certain aspects of that law?
I don't have knowledge of that one.
That as a police investigator, I investigated a complaint that was made under oath of a sexual assault, and we had very, very clear evidence that complaint was false. And I told you that the state's attorney's office took a position that in an effort to not deter people from coming in, they did not want to charge that person with a false statement. Would you take my word on that?
I would take your word on that.
And if a woman chooses to protect herself with a firearm, she would need to be able to use that firearm in a threatening manner to that attacker.
I think that if a woman chooses to protect herself with a firearm, that it could be characterized as a potential to harm her batterer, yes.
So that batterer, now having been exposed to a threat, risk of imminent personal injury to himself,
Right.
now can go into court and say, this woman poses an imminent threat to me. And he can say that without lying, because she does pose a threat to him, but it's a legitimate threat.
Well, true, but I think that the court has to find that there's no other reasonable alternative before removing her gun. That's my understanding. I suppose the other alternative would be to put her in jail.
Where do you see that in the bill?
That's what's been testified to here today. That there is that this is a last resort. Our risk warrant law is a last resort. Removing someone's firearm is a last resort.
Okay, so in your opinion, it should be a last resort.
Yes.
Okay, so in your opinion, there should be no other alternative.
Yes, there should. Right. If a firearm needs to be removed, it is because there is no other alternative. Yes.
So under current law, there must be a showing of probable cause and a showing that there is no reasonable alternative available. Now, do you understand that under this bill, that's no longer the case?
No, I do not understand that under this bill, that's no longer the case.
Well, let me ask you this. Under the current law, it's an attorney, a state's attorney, an assistant state's attorney, or police officers that have to certify that they have conducted an independent investigation and determined that there is probable cause and that there is no reasonable alternative available. Okay, is that your understanding of current law?
That's my understanding, yes.
Okay. Under this bill, a family member or household member can file the complaint without doing that investigation and without determining that no probable cause exists and that no reasonable alternatives are available. So under this bill, those protections that you just said should be in are no longer applicable when a family member or a household member files the complaint.
That's not my understanding. My understanding is that it's up to the court to decide what a reasonable alternative is. The court is ultimately making the decision.
Can you point me to any portion of existing law or this bill that indicates that that would be the case if this were passed?
I can't point to a specific line.
And it's your understanding that under this bill, the court cannot accept the complaint unless there is no reasonable alternative?
That is my understanding.
I would suggest to you that your understanding is incorrect and that you should read the bill again because that's not what it says.
Dr. Walkupson, and I'd like to testify in support of House Bill 6491, the act concerning non-lethal electronic defense weapons. There are many people who would like to be able to carry a firearm and some that don't wish to carry a firearm, and this gives them an excellent ability to defend themselves without it. All I need to do is just reference the Supreme Court case Catano versus Massachusetts, where it found that laws restricting non-lethal electronic defense weapons were unconstitutional, that the Second Amendment does extend to all tools and instruments that can be used for self-defense. There was a comment about how, or an insinuation that tasers didn't have any legitimate purpose. And I would ask, well, then why do police officers carry tasers?
My name is Peter Strada. I'm a representative also of Connecticut Citizens Defense League. I'm the Urban Engagement Coordinator. What safeguards are the representatives here going to put in place in case if someone was falsely accused, the judge did feel and finally did decide to return the firearms, making sure the state, the police do not destroy those firearms? If that does happen, will you be compensated? The permitting process. If I'm cleared, my permit was revoked or suspended, whatever it is, the term they use. If I have to reapply, that's a question on the application process. Has your permit ever been suspended or revoked? And could the issuing authority, the town, now use that as a reason to then deny me in the future to issue a new permit?
My name is Ray Beavis. I do have great concerns that an unintended consequence of this, of 6355, if passed, will increase firearm-related suicides. As we saw one such measure in the passage of Public Act 13-3, by adding mental health or by adding medical professionals to the list of petitioners who could go directly to the courts to petition for an ERPO without the investigation, I believe law enforcement officers and firearms owners will even be further deterred from seeking outpatient mental health treatment. I think this stigmatizes mental health in firearms owners and police officers. I also am opposed to the removing of the transfer of third-party on lines 116 through 117 of the bill. We have to remember that some firearms are actually family heirlooms that have been in possessions for families for 70 to 80 years and not only have monetary value, but even greater sentimental value.
You briefly mentioned lines 116 and 117 and the change in this bill that's represented there. Could you just explain what change represents and why you would oppose it?
So what that change represents is currently under current law, someone that has an ERPO issued against them can transfer their firearms to a third party, provided that third party is qualified and is permitted to have a firearm, and provided they go through desk, get an authorization. Under this bill that removes that, so it only gives the person that has the ERPO against them two options: one, to remain in police custody, and as we know, police can destroy them after 12 months, or second, have them held by an FFL. And my main concern is we have a firearm in my collection that was my great-grandfather's. It's been in our family for almost 80 years. I would feel really horrible if that firearm got damaged in a police storage or evidence storage facility, or even just manhandled in the back of a police car and thrown into a pile of firearms.
So, for example, if somebody if somebody went to court and had one of these warrants, one of these orders issued against them under current law, they could, for example, transfer their firearms to parent or somebody else who was authorized under law to possess firearms. Is that right?
That is correct.
Okay, and under this bill, that would no longer be the case?
Yes, that's my understanding.
In the case of filing any type of false request or complaint or any type of restraining order, did that individual, was he ever charged or making a false statement under oath?
And my lawyer at the time kind of snickered and he says, "That's not how it works." And I said, "Well, could we go after him civilly?" And my lawyer's response was, "The guy doesn't have a house. He doesn't have any assets. What is he going to pay you?"
My name is Holly Sullivan, and I am the president of the Connecticut Citizens Defense League. I would like to express my sincere desire that this committee move forward with HB 6491. As a single mother, I'm extremely cognizant of my responsibility to protect not only myself, but my 7-year-old daughter. I work full time, and it leaves me juggling errands often in the evening. I'm often assisting my daughter getting buckled into her booster seat in a parking lot of a grocery store, Target, etc. Having been raised with firearms, I made the decision years ago that I wanted to be trained and to properly carry a firearm responsibly. However, I've had conversations with many women who expressed to me that they just are not ready or do not wish to have this responsibility. And I understand and respect this. Owning a firearm is not for everybody. However, these same women have also expressed frustration that they have few tools available to them as an alternative outside of their home. In our state, a woman can secure a permit which grants them the means to take lethal force if needed. However, women in this state have no avenue to protect themselves with non-lethal force outside of the home, and that doesn't make sense. Further, there are many instances in which a woman like myself may not have the ability to carry a firearm due to the circumstances of the day. I work in Brookfield, about 10 minutes from the New York State border. If I need to run an errand or do business over the state line, my firearm absolutely cannot come with me. Most women in this country do have the means to protect themselves with non-lethal electronic devices, including states like New York, California, and New Jersey. We are the minority in this. So I do hope that this committee will support a truly common sense proposal for the safety of women in our state. I'm also here today to strongly urge you to reject HB 6355. The passage of this bill will undoubtedly have severe implications for genuinely good people in this state. I'm sure you're going to hear a lot about due process, but I want to ask you to consider the impact that this bill will have on mental health in our state. I have on several occasions spoken with women gun owners who are afraid to get basic mental health in our state. I have on several occasions spoken with women gun owners who have issues such as a very basic things, such as eating disorders, postpartum blues, or going through marriage counseling. They're at no risk to themselves or others. However, there is certainly stigma and confusion that they will have their firearms taken away from them and they won't be able to defend themselves. and I've dispersed this misconception and assured them that currently, with no threat of harm to themselves or others, outpatient counseling would not be an issue. However, under this bill, I'm concerned that more women will avoid seeking basic mental health over the concern that they might be disarmed unfairly, seeking the advice of just a social worker. Women gun owners in our state must feel comfortable seeking access to mental health, and I would implore this legislature to do so. This bill is contradictory to accomplishing that. Thank you.